Hi, y'all, and welcome to tonight's live stream. Well, usually a murder trial is dramatic in and of itself, and it hits the crescendo when the jury returns the verdict. But in Ashley Benefield's case, major drama is unfolding after the verdict was delivered, after she was convicted of manslaughter for shooting her husband to death. Ashley's lawyers are claiming that the jurors engaged in some major misconduct. They say that one of the jurors leaked from inside the jury room and that her brother posted the information on Law and Crime's chat as everybody was waiting for the verdict. They also say one juror withheld critical information during voir dire, which is when the lawyers get to ask the jurors questions to decide whether they might have some bias against the defendant. So the judge is concerned enough that he is actually going to call the entire jury in and question them about it. And at least one juror has already hired a lawyer. So let's do a quick recap of the case. At age 33, former ballerina and swimsuit model Ashley Benefield was 25 years younger than her husband, Doug. They had one child, but they were estranged and they were living apart at the time Ashley admits she shot and killed Doug. Now, Ashley had accused Doug of DV against their daughter and against her, but the charges really hadn't stuck, and Doug said that's because they were utterly false. Now, Doug, at least, seemed to think that they were getting back together. I'm going to make sure that, yep, everything's good. Okay. Checking to make sure all the sound and everything was good for y'all. Okay. He was helping Ashley pack up for a move to Maryland, and he was planning to go along too. It wasn't entirely clear if they would be living together, but they would both be in Maryland. They were both going to move there, in his mind anyway, together. So Ashley took the stand at her trial for Doug's murder and told the jury that she and Doug got into a fight as he was in her house helping her move. And she said he attacked her and she grabbed a gun and shot him, and it was self-defense. That was her argument. The state said Ashley planned all this and that she did it because she wanted sole custody of their child. So that, in a nutshell, is what the case was about. The jury, at one point during lengthy deliberations that went at 10 p.m. at night, it was about 6 hours of deliberations, they announced they were not going to be able to reach a verdict. But the judge said to them, well, would you like to come back tomorrow? And they went out to decide that, and they just decided to keep deliberating. So they went for another hour and finally came back with a manslaughter verdict. They did not find Ashley Benefield guilty of second-degree murder, which had been an option, but they did add the enhancement because the manslaughter was done with a firearm, which would add extra time to her sentence. All told, she's facing somewhere between 11.5 and 30 years in prison. Now she is saying she ought to get a new trial. She has several reasons. She filed a lengthy motion, but we're going to talk about the most dramatic one of all, which is her allegation that jurors engaged in misconduct. So let me say a special shout out to the first 5 in the chat: Olivia's mom, aka Sue, Elizabeth, Michael Lalonde, Loretta Powell, and Licia M. Also, thanks to Lisa Morehouse, who wrote and wanted me to cover this if I could. All right, so the two issues that they are bringing up are, number one, that juror 15, they say, the defense says, gave false answers on the juror questionnaire. The judge is calling her in to interview her about that, and she has lawyered up ahead of the interview. Now, second thing they talk about is that somebody named That Hoodie Guy, posted in the chat of Law and Crime's trial live stream as everybody was waiting for the verdict to come back. And the person said their sister was sitting on the jury and had smuggled in a flip phone. They weren't supposed to have phones in the jury room, and was texting out updates, which he was passing along. Now, based on timing, the defense says, we think it was real. We think this person truly had inside information. So, and then the third thing I want to talk about is sort of how the judge is going to make the decision. How will the judge decide whether or not this is actually something that would get her a new trial or not? Because all he's decided so far is that he's going to talk to the jurors. That's it. That he's going to interview the jurors. That in and of itself, though, was a pretty huge win for the defense. So we'll talk about all of that. Remember that Ashley Benefield, like all of us in our country, was entitled to her rights under the Sixth Amendment to have an impartial jury. And she says issue one was that juror 15 gave false answers, first of all, on her jury questionnaire, and second of all, in her answers in voir dire, which is when the jurors are asked questions by the lawyers. Also called voir dire in some parts of the country. I always throw that in because otherwise people, hey, you said it wrong. So one of the reasons that the defense says this really matters is apparently, and I've never heard of this ever, they did not use one of their peremptory strikes. When you do jury selection, the lawyers are allowed to ask questions and they get a certain number of strikes. They'll argue to the judge, jurors 1, 7, and 12 could not be fair for the following reasons. You need to strike them. And if the judge says, I'll do 1 and 7, but not 12, then it's up to the party to use one of their strikes to strike that juror, or to decide another juror would be even a bigger risk for them. So that's what the defense says. They still had one left over when they reached the end of jury selection. They were apparently pretty pleased with the jury, but they say had they known the information that this juror had, if she had been truthful, they would have struck her. And so that's what the argument is all about. The jury filled out questionnaires before they got to trial, and the questionnaires would just have general questions. Some would be very specific. They would have been worked out between the parties and with the approval of the judge. And some of what they asked was related to DV, since that was the issue in the case, both because Ashley had accused Doug of that and because she said she was in fear for her life from him. So that is what the issues that they were asking about and that they believe the juror lied are about. So let's go ahead and take a listen to some. It was a lengthy hearing, so we're just going to listen to a few little clips.
Questionnaire, Your Honor, contains a very obvious admonition that says, under penalties of perjury, I declare that I have read the foregoing jury questionnaire and swear or affirm that the facts stated in it are true. Now, one of those questions, as I've highlighted for the court and for the record, is, quote, have you or a member of your immediate family been, unquote, victim of a crime? Ms. Walcott put an N in that block indicating no.
So let's stop there for a minute. The fact that this representation was made on a jury questionnaire was one of the things that made the judge wonder whether or not she needed to get a lawyer, because he said this is something that's filed under oath. So the fact that she swore and affirmed that the facts in it are true and that she did that in the context of the court made him wonder about whether she needed an attorney. And in fact, the defense says this juror 15 actually had been the victim of a crime. A DV injunction had been filed against her as well. Had been filed by her against her boyfriend for assaulting her. And they say that's exactly what we were asking about. And she wrote no.
Filed in our motion for new trial a domestic injunction petition filed by Sarah Walcott. The facts also include are that her then boyfriend, Albert Ballinger, was arrested on February 20th, 2016 for allegedly grabbing her hair by the back of her head and slapping her across the face 5 times. The deputies observed redness on the left side of Miss Walcott's face. Mr. Ballinger was arrested, and Miss Walcott filed a petition declaring herself to be a victim of that offense. That is in absolute and direct contradiction to the form that she signed on. Ms. O'Donnell.
So the questions that were asked on the jury questionnaire are one issue, but there were also specific questions that were asked in the voir dire when the attorneys asked questions on the jurors. And the defense lawyer goes through and catalogs some of those. The way it was done was They would ask a broad question, have any of you ever? And the jurors had paddles, and they would hold it up if the answer was yes, and then they would, okay, 5, 7, 8, and 12. Okay, and then they could come back and ask those individual jurors questions once they've noted that they had raised their paddle and that they were answering yes to that issue. So the next issues relate to what was said in court as the attorneys were asking questions.
Asks, have any of you here ever had any dispute with your significant other about your child or the custody of your child? Additionally, Ms. O'Donnell asks, has anyone here ever had like a heated custody battle with anyone? She then acknowledges another juror, 26, who raised their hand, and she goes throughout her voir dire very meticulously, back and forth, each side of the courtroom, left and right. And finally, on page 239, Ms. O'Donnell goes back to the other side once again, and on line 8, she asks, anyone else on this side of the room? Okay, no one else.
So this is going to be hotly contested by the prosecution. The prosecution says, I wasn't that meticulous. I just picked a few and asked. I don't normally ask every single juror every single question. I was just noting some names. I wasn't attempting to get everybody. We'll hear her argument in just a minute. But the defense followed up on some of that questioning by the prosecution, seeking information about custody disputes or DV experience with males in DV situations, that sort of thing.
I asked the following question of the veneer. Has anybody in the prospective veneer been involved in domestic courts? There's a show of paddles. I follow that up by asking on page 284, line 8, how many of you know or have experienced a male?
Every time you hear that beep, I'm putting that in to indicate I removed a word that would be sort of a trigger word for YouTube.
The court reporter, of course, is diligently noting the paddle numbers of the jurors that respond affirmatively, and the court will note juror 15 is not among them at any point. And the court reporter even goes so far as to say on line 22 of the same page, 284, court reporter, wait a second, I need your paddles, don't just yell out.
The defense is saying that there was a real attempt to cover all of the jurors who might have answered these questions because it was critical that both sides know what their background and experience in that area was. And so juror 15, the defense is saying, never spoke up. At no point did she ever say, yeah, I have this background, these things have happened. And the defense says, and we've got proof that she did have that background.
We provided the court with a domestic injunction where Sarah Walcott was the respondent, the person that it was filed against. This was a domestic injunction filed and sought by her ex-husband, Charles Walcott, on behalf of their minor son, Hayden Walcott. The ex-husband sought custody of the minor son. The petition was ultimately dismissed, but for our purposes, that's completely irrelevant as it was filed against Ms. Walcott. We attached another domestic petition filed against Sarah Walcott.
Sorry, that was a little long.
It was an injunction once again sought by her ex-husband, Charles Walcott, once again on behalf of their minor child, Hayden. In this instance, the court issued a temporary injunction to Mr. Walcott, and Mr. Walcott sought and was granted temporary custody of the minor child, Hayden Walcott. Mr. Walcott's accusations in that petition alleged child against Sarah Walcott, and specifically stated that Sarah Walcott, quote, picked up the minor, Hayden, by the arms and slammed him against the wall. The significance of that, of course, Judge White, is that Ashley Benefield made child allegations against Douglas Benefield.
So they managed to find not just one, but two different allegations related to this juror being accused of DV. And they're saying, if we had known that, we knew that it would be controversial that Ashley had accused Doug of DV. And here's someone who has also been accused of that and may feel, who knows, that she was falsely accused and therefore might side with Doug. So we would have struck her. That's what the defense is arguing, is that this person had relevant experience right in the area we were looking for, and she didn't speak up. And we can see it here in court records that we're providing to you, Judge, and that you too can see. It's not just DV allegations against Juror 15 herself either. There were also two different allegations against her adult child, one for DV and then one for a bar fight. And before I play that little clip for you, I want to say thank you, Marlon. I appreciate it. I am definitely feeling better. Y'all have poured in the suggestions for me. I think I'm taking like 12 different things, including Manuka honey drops, and Manuka honey in tea at night. I mean, you name it, and y'all have suggested it, and I'm so grateful. And I'm definitely improving. So thank you for all your suggestions. And I'm so glad you've been a member for 7 months. That means we're hitting 7 months. And Janet, thank you. I'm glad for that, for you being a member that long too. And like she says, I forgot to say, don't forget to hit the like button. So please do. It will really help the video get out. And subscribe. We would love to have you back for more. So let's get into the next clip.
And the court may recall that the petition, the questionnaire rather, that Ms. Walcott executed says her or her immediate family, which would include her child, Hayden Walcott. We attached as Exhibit F an aggravated battery charge against a pregnant victim, case number 2014 CF 3121 against Hayden Walcott. She was, the victim, Mr. Hayden Walcott's live-in girlfriend. He appeared on the scene heavily intoxicated, and Sarah Walcott posted the cash bond for him to be released. Once again, despite the question about domestic, no disclosure. And finally, Your Honor, again, as it relates to the voir dire, in a bar fight, charged with felony battery on June 1st, 2024. This would have been right prior to us selecting the jury and the trial commencing. This is a bar fight on June 1st, 24, where Mr. Hayden Walcott is observed on video, according to the deputy, punching the victim in the face with, quote, significant force, once again not disclosed in voir dire of the questioning of Ms. Walcott about males or domestic. There was a dispute.
Lots of YouTube trigger words there. So this last one is particularly significant because it was so close in time to when the juror questionnaire was filled out. It was just right before the trial, the defense is saying. And the defense is saying there was another issue related to juror misconduct. That was a significant one, Juror 15, and her failure to answer their questions. And they said that would have really mattered to us. We actually would have made different decisions. We would have used that last strike to remove her had we known that these things were true. But she didn't tell us, so we didn't know about them. There's a second issue that involves what I'm sure is one of all of our favorite YouTube channels, the Law and Crime channel. They were showing the trial and everyone was waiting for the verdict. And during the chat, enter that hoodie guy.
Dispute with the court about whether or not the jury knew that they could ask for a readback. But what then followed, Your Honor, was a really puzzling and very alarming recitation of events on a public website by law and crime networks called Verdict Watch. we were able to capture it before it was taken down, and it was taken down pretty soon after it was posted. But there was an individual by the name of that hoodie guy. And what was so alarming about this was that everything that the hoodie guy reported came to pass exactly as he reported it, but a couple of minutes later by the jury. So for example, at 10:20 p.m., 10 minutes before the parties were notified that a verdict had been reached, the hoodie guy posted a comment stating, "Verdict incoming."
Okay.
Now, there wasn't actually all that strong evidence about the timing. The defense offered screenshots, but law and crimes moderators removed these fairly quickly after they were made. And so they weren't still available on the site when the defense went to look, but someone sent these, and the defense offered to present that person by Zoom for testimony, but the judge refused to allow that because they had not named the witness in advance so that the prosecutor could prepare, talk to the person in advance, and so forth. So now I want to, before we switch, I want to take a look at the here, let me make that a little bit bigger. Okay, so I want to take a look at the actual emails before we get into the testimony about them. Or not emails, the chat by that hoodie guy. I've marked them in red, and I just want to read through them. There are about 5 of them. That hoodie guy said, "Verdict incoming. I did note one of our regulars, our own Misconstruct, is part of the court pleadings, part of an exhibit to one of the court pleadings." That hoodie guy said later, "Per sources, 5-1 guilty, with the man stuck on not guilty or manslaughter." In other words, nobody was going for not guilty. And my sister snuck a flip phone in, and I noticed this. Peaches 523 said they had to turn in all electronics before going to deliberate. That's ridiculous. And that hoodie guy said, "I am the brother of one of the jurors. She just texted me this. Per sources, 5-1 guilty, with the man stuck on not guilty or manslaughter." Now, the prosecutor is going to say a lot about that per sources. The prosecutor is going to say, why would a juror actually sitting inside the courtroom talking about what is happening right that minute for them, why would they say per sources? That sounds like somebody who isn't directly in the jury room. They said that just doesn't sound right. And that hoodie guy said, "My sister snuck a flip phone in. She texted me 5-1 guilty, may compromise on manslaughter." So those are the text messages. Now let's get back to the video.
The second thing that happens,
Not
that at
chat.
10:25 p.m., moments before the jury comes in, that hoodie guy posted a comment stating, quote, "Per sources, 5-1 guilty, with the man stuck on not guilty or manslaughter." Now, the court may recall that following that first question and the dispute about the readback, the court told them, "Rely on your recollection," and sent them back out. They returned shortly thereafter and said that they were hung. This was what was posted as a result. The next thing that's posted at 10:27 p.m., according to that hoodie guy, is a comment stating, "My sister snuck a flip phone in." At 10:28, Your Honor, that hoodie guy posted a comment stating, "I am the brother of one of the jurors. She just texted me this. Per sources, 5-1 guilty, with the man stuck on not guilty or manslaughter." At 10:28, that hoodie guy posted a comment stating, "My sister snuck a flip phone in. She texted me 5-1 guilty, may compromise on manslaughter." And at 10:30 p.m., the jury comes in and announces they have a verdict of manslaughter. And that was a mere 2 minutes after the hoodie guy posted what he did.
So the defense says this is an insider. This is somebody who carefully was tracking exactly what was happening in the jury room and releasing that to the public. And that means there really was someone in the jury room sending these messages out. And judge, you ought to look at it. Now, the defense also reminded the judge, look, we want a new trial, but all you have to do first is just interview the jurors. That's the first step. And they say that's not that high a threshold. Here's their argument.
I would remind the court that the standard in the rule is not very high. It requires reasonable basis to believe that the verdict may be subject to attack. And if so, if that is shown, the court does not have discretion according to the rule. The rule says the court shall order an interview. And of course, that's the whole purpose of the interview.
Now, the prosecutor gave a rousing response. It was just blistering. It was extremely well done. Prosecutor didn't win the day on this, but had very heartfelt arguments. The first thing she talked about was there's just no real proof that there is an exact record of which jurors raised their paddles for every single question. Here's what she said.
The representation that Mr. Taylor has made about what happened in jury selection with those paddles is completely and 100% inaccurate. When those questions are asked, paddles are raised. The court reporter does not write down the number of every paddle that was raised. Not once have I ever seen in a transcript that the court reporter tries to write down 30 different paddle numbers as to who raised their paddles. I can represent to the court that I almost never go to every single person that raises their paddle. That is a habit of mine. It is quite possible that Ms. Walcott did raise her paddle, and we are sitting here maligning her, acting like she withheld this information inappropriately, which I find highly objectionable. And
now, the prosecutor also argued that it's the argument that it's just a low bar to be able to conduct interviews. That can't be right, she said, Judge. That can't be right. And she had a pretty good argument about why that shouldn't be correct.
The rules for this sort of thing, interviewing jurors, yes, jurors can be interviewed, but what Mr. Taylor did not mention is how strict the standard is in order to get to the point where you interview a juror because of public policy reasons. Because how are we ever going to get jurors to come in here if they know that after the fact someone is going to dig into every aspect of their life and call them liars when they didn't lie and distort the record to meet their own needs?
And as for that jury questionnaire response, she says, well, that question that was asked was kind of confusing. It asked whether the juror had been a victim. And she said that could be defined a lot of different ways. And it's really up to the lawyers to clarify that. If it's not clear on the questionnaire, then to clarify that by questions asked during the voir dire.
And using the questionnaire where it says, have you or a member of your immediate family been the victim of a crime, yes or no? And it is checked no. There is no evidence of any intentional deception. There are very, very different definitions of the word victim. Is it a victim in an injunction? Is it a victim in a crime where someone is arrested? How about if you're a victim and someone is not arrested? How about if you're a victim and the police come out and they don't even file charges?
And she pointed out that usually in the law, we won't accept anonymous sources. By definition, those are people not in front of the court. That's hearsay because the person didn't show up, and they're very suspect because they aren't there. And she says, when the name, that hoodie guy, that's about as anonymous as you can get. We don't accept anonymous sources, she argues.
I do believe that there is some discrepancy about exactly when these comments were coming in, but it is also the state's argument that this is an anonymous source. And we know from the law and how we deal with anonymous sources, they are given the very least amount of credibility.
And then she argues that there is no indication that anybody from the outside influenced a juror. I mean, it would have been inappropriate for somebody inside the jury room to send a message to someone outside because they weren't supposed to have phones. They weren't supposed to be in communication with anybody. But she said sending a message out is not the same thing as being influenced. Ashley Benefield's right is to an impartial jury. The fact that the person sends a text message out doesn't necessarily reflect on that. That's her argument.
Also, Judge, even if you do take that this person somehow had a flip phone in the jury room, there is no indication that there's anything other than outgoing texts. Even if there is, which I don't think there was, but even if there is, these are outgoing messages. There is absolutely no evidence or even indication that there was anything incoming that would have tainted this jury.
So the defense says, look, outgoing messages mean incoming messages, chances are, and also that it listed some of the things that they want the jury to be asked. The judge really latched onto this. This is what he thought was very important.
Again, the timing involved and the sworn allegations made by Mr. Taylor and the attachments establish that there's a reasonable possibility that there's a cell phone in the jury room, and then thus a reasonable possibility that there were not only outgoing messages, but incoming messages that may have been shared with other members of the jury. So the first question to each juror would be, did you bring a cell phone into the deliberations? Did you see anybody else with a cell phone? Did you see anybody else leave the room and go in the bathroom and hear them talking on a cell phone? And if any of those answers are yes, then short follow-up, was any information shared with you from the information that was communicated on the cell phone? We don't get to ask, did they rely on it? We don't get to ask, for their cell phone number. We don't get to, expect their cell phone. We get to find out whether they saw a cell phone, they brought a cell phone into the room, or whether they saw anybody else, and whether that cell phone was used, or the information from the cell phone was used during the deliberation.
Now, the judge liked that because it was pretty limited and specific to exactly what the issue was, the use of the cell phone and how it was used within the jury room. So the jury did want to know who that hoodie guy is, but Law and Crime is not saying anything.
Do you know what efforts, if any, have been undertaken to this point to identify that hoodie guy? All right.
We were shut down pretty decisively by the television station.
Which you would expect. So at this point, the judge ruled in favor of the defense, saying, I will interview all the jurors. But he pointed out that interviews is not even close to the same thing as granting a new trial. That's simply talking to the jurors. It's a much smaller deal.
I just happen to be there the whole time and have a very firm remembrance of what happened. With that said, at this point, the only issue that is before me is whether to grant the interviews or not. I don't make findings of prejudice. I don't make findings of credibility. I'm not in any way interpreting the posts that appeared. It is extraordinary. There's no doubt that this is an extreme step. But at this point, there is sufficient evidence in front of me to grant the request for the interviews.
Now, it was really interesting to me that he explained he started out most concerned about that hoodie guy and the comment in the chat on Law and Crime. That was his first concern, but that having listened to everybody at the hearing, he was now also very concerned about the Juror 15 issue.
The cell phone issue was certainly, factually speaking, I think more clear in my mind and towards granting the request for the interview. But as I heard the argument and considered everything today, I think the defense has made, I don't want to say a prima facie showing, but I'll use that word, I'll adopt the word you all used, a prima facie showing that you should be allowed to ask some questions and clarify from Juror 15. Jury question.
So in fact, he's so concerned about Juror 15 that he posed the question, everybody, does she need counsel? And should I offer her a free lawyer if she's unable to afford one on her own?
Questionnaires, this is not something we often think about when we're picking juries, are essentially, while not under oath, there is certainly a written, it reads very much similar to the written declaration in lieu of notary in 92, chapter 92, 585? Don't quote me on that. I think it's 585, but it's somewhere around there. The written declaration in lieu of notary, and it does make me think that I should at least offer counsel to juror 15 and at least give her the option of that.
Now, the defense agreed with that, said, yes, we think you should offer an attorney if that's something that she can't afford on her own. And probably the defense went so far as to suggest that she would need to take the fifth. I'm going to talk about that in just a minute, but first I want you to hear what the defense said.
My perspective as criminal defense attorney. If Ms. Walcott or if somebody similarly situated
Very
as Ms.
soft-spoken.
Walcott were to come to my office and I made arrangements to represent them, I would advise them to invoke their Fifth Amendment right to remain silent for two bases. One, potential perjury, and we can say, Suzanne can stand up and say, look, we have no intent of charging.
You know, this is our last one, so I am just going to stop that.
And for the record.
I'm just going to read that because I think that's too hard to hear. It says, if somebody similarly situated as Miss Walcott were to come to my office and I made arrangements to represent them, I would advise them to invoke the Fifth Amendment right to remain silent for two bases. One, potential perjury, and we can say, the juror can stand up and say, look, the prosecutor can stand up and say, look, we have no intent of charging a former juror. She may feel differently, or her office may feel differently in the event this results in a new trial. And secondly, I would advise my client to invoke the Fifth Amendment, Judge White, based on the fact that as a result of this trial, of her failure to respond properly to the voir dire questions, that she has exposed herself to direct criminal contempt by the court. And the court may very well have the authority to assess costs of that prior trial. So I think you'd be doing the right thing to advise her. I'm just going to make the offer. The judge says, I'm just going to make the offer. Do you want to be heard? Asks the state. State says no. Okay. All right. So I'm going to advise juror 15 that she is certainly entitled to hire an attorney, or the court will consider appointing an attorney to represent her if she financially qualifies, and then she can make those arrangements through my office. So now I want to talk for just a minute about what that would mean. Now, the defense probably would like for her to take the Fifth Amendment. The judge would then have to presume that some of the defense allegations as to juror 15 are true, at least probably. They do seem to also be proven by court documents. So the defense will be relying on two things, the court documents, and if the juror took the fifth, there'd be no contradiction to that. So that would be some powerful evidence then in that case. Juror 15 did lawyer up, and on Friday, a lawyer made an appearance on behalf of the juror and asked for a copy of that jury questionnaire that she had filled out. But her lawyer suggested, let's go ahead and add this to the stage, suggested to me, here we go, the notice of appearance, I'm going to make that bigger, that she's going to cooperate. Said the court has granted the defendant's request to interview the jurors, and Ms. Wolcott has every intention of cooperating and answering all of the court's questions. In order to be fully prepared, Ms. Walcott and the undersigned request that the questionnaire at issue be provided to the undersigned by September 27th, 2024. So she may well have what she believes was a misunderstanding, or may feel like, yeah, I raised my paddle. I don't know why they didn't call on me. They certainly could have. I raised my paddle. It could be anything along those lines that she plans to say. So the judge has set out... All right, just a second. The judge has set out sort of a process to use, and what the judge is going to do, actually subpoenaed the 6 jurors who sat on the Benefield jury, and they talked about, the judge said, well, should I ask the questions or you? You may remember in the Murdoch trial, that was debated, but ultimately the judge asked the questions. And that's what the defense said. Well, while I would like to ask the questions, truthfully, we'd probably get better answers if you ask them, Judge. So the judge said, yeah, I agree, and I'll do it. And the judge also asked them, should this be public or is this in camera? And they said, the defense again said, well, we'll probably get more correct answers if we do it in camera, meaning we do it outside the public, something private. And so that's how it's going to go. It's going to be done privately. It'll be October 4th. So I was going to cover how the judge will make the decision, but I think I've lost my voice for now. So we will call it a day. I will look forward to seeing you Wednesday at 7 p.m. Eastern. Please be sure to like and subscribe. And thanks to Marlon and Mama Pinks, our moderators.